It took 35 years and 12 DUI convictions for a Lake County man to receive an extensive prison sentence. Irina Cates takes a look at Montana law and what it takes to prosecute and sentence DUI offenders to prison.
Driving under the influence of drugs or alcohol. We see the results of this choice tearing apart our Montana communities multiple times a year.
Some of the most painful cases you ever see in the courtroom from all angles are the ones where somebody is hurt as a result of that choice. From watching the amount of pain, I would still continue to recommend, please don't drink and drive.
13 months in the Montana Department of Corrections plus a 5-year suspended sentence. That's the maximum a judge can impose on someone convicted of a felony DUI.
You have to sentence them to 13 months. The Department of Corrections then is supposed to put them in an appropriate placement, presumably a treatment facility, which the Department of Corrections has one they call WATCH. And that's a 6-month program.
So if the offender successfully completes that program, the rest of their 13-month sentence can be served on probation.
And then they tip over into that second portion of the sentence, which is up to 5 years commitment to the Department of Correction, which is all suspended. So it's possible to get DUIs and have them be treated almost like a first felony DUI multiple times.
This 13-month DOC and 5-year probation sentence doesn't typically change even in multiple felony DUI convictions. The only way it could change is if the county attorney's office files what's called a persistent felony offender notice.
That's only filed in situations where it works, which means that you've had a prior felony within 5 years prior to the commission of this one, or you're still pending and serving the sentence on that earlier felony.
In this situation, the maximum sentence can be up to 100 years in the Montana State Prison. But prosecuting DUI offenses can also be challenging, and one of the problems is proving someone had prior DUI convictions.
We usually have to be able to prove that they were either represented by an attorney on those prior convictions or that they waived their right to an attorney, and that usually requires a written waiver. There have to be records. That's often difficult to prove, particularly if somebody's prior DUIs occurred in another state.
So the sentence someone receives could change from the time they were charged with the DUI to the time they're sentenced for it.
If we do deviate somewhat from a standard sentence, it's usually because we don't have as strong a case as we would like to have, and it's better to get a plea of guilty to something with a slightly less serious sentence associated with it so that you hold people accountable for their actions.
You may have a legal right to do it to a certain point until you're unable to safely operate a motor vehicle. If you're wrong, it tears up lives.
Irina Cates reporting for Montana's news station.
Now, this issue triggered a lot of chatter on our Facebook page. Lana said this: if they sent every felony DUI offender to prison, there wouldn't be enough jail cells in the state. Jesse wrote, it's a problem that goes unaddressed because the state makes millions of dollars on taxing the sale of alcohol and off fines paid by DUI offenders. And Shane said, I wonder how many more people have to die before the laws change. You can chime in as well. Just go to our KPAX Facebook page.
The